So what we'd like to do is have a conversation with you today about some of the things that we recommend to clients every day, especially entrepreneurs that are beginning a new business venture. You know, whether they're doing it from their garage or whether they're doing it as part of a venture capital fund or even on the university campus, the kinds of issues that they face are going to be basically the same. So what we'd like to do is discuss, again, the kind of advice that we give to these companies about how to establish themselves the right way, how to protect their intellectual property, and how to use contracts, among other things. And after about a half an hour or 35 minutes of that discussion, we're here at your disposal to ask questions that you have on your mind as you start to plan your businesses. So with that quick background in mind, I'd like to introduce my partner and longtime friend, Marco Gonzalez, who will start the presentation about legal basics for entrepreneurs.
Thank you, Chris. Good evening, and I hope everyone is well and healthy. And so, like Chris said, we're going to talk about some important information in several areas that every entrepreneur should know about, especially startups. And then from there, we're going to go and discuss, whatever questions you have. So we're going to understand a little bit about why is it important for entrepreneurs, startups to know some of the basics of the law. Business formation, we're going to talk about that, contracts and agreements, intellectual property and branding, and we're going to close up with some information regarding compliance and litigation. So why is it important for you to know some of the basics of business law? It's simple. It's to minimize risk and potential liability of your business. How you set up the business, the formation, what you got to do to register, negotiating, drafting contracts and agreements. When you have employees, dealing with them, what are the legal obligations you have to your employees? Especially you guys who are doing all of this innovation and invention. IP is a big part of what you need to understand. When you sell things, you're part of your business, assets, you need to understand a little bit about that. And of course, most businesses, over 63% of small businesses, have to comply with a state, federal law or local ordinance or statute. You need to know a little bit about that. And of course, the dreaded L word, litigation. So let's go into formation. It's important for a variety of reasons. You can see in this slide, and we're going to give you a copy of this. Tax considerations, if you have a brick and mortar establishment, zoning, licenses, registering your business with the proper authorities, and creating the proper setup agreements if you have more than one owner of the business. These are all some of the considerations you need to factor in when starting your business. So business formation, the different types. The basic one, I'm not going to go into great detail, is a sole proprietorship. You know, if you have a hot dog stand or some type of vending operation on the street, that may be okay. We really don't recommend that anymore for our clients. So the next type of business that we see a lot are partnerships. And basically, it is a union of two or more people who share ownership in the business, and they contribute to all aspects of the business: labor, money, capital, skill, and in turn, for that, the owners, the partners, share in the profits and also in the losses and liabilities of the business. So the advantages are set over here: ease of formation, low startup costs. You know, the more partners you have, the more venture capital you could bring in, broader management, and limited outside regulations. And I like to, we're to say that partnerships can be made of individual persons and also other business types of businesses, LLC, corporations, and the like. So you're not limited to just setting up a partnership through natural persons. So remember that. There are some disadvantages, especially if you have a partnership made of just natural persons, is unlimited personal liability. I'm going to discuss that a little more detail later, what that means. Lack of continuity, divided loyalty. partners sometimes bump heads when they don't agree on the same objectives of the business. And it can be difficult to raise capital when you have only one or two partners of a business. But I think the most important disadvantage is trying to find a suitable partner, because you're doing basically a business marriage here. And that's a big disadvantage, especially if you don't do your due diligence in who you're going to do business with. The next type, and it's very popular now for the last 20 years or so, is an LLC, Limited Liability Company. And that's an entity that's created by the state. You know, it's an entity that can sue, be sued, have a bank account. And the good thing about an LLC is that, and most states have a LLC statute, including New Jersey. They may be different in how you form it. And so we're not going to go into that in great detail because it depends on what state. But New Jersey is fairly easy when you have the right law firm with you as part of your team to set it up. And basically, it combines the benefits of having a pass-through taxation of a partnership or sole proprietorship, but with the benefit of having a limited liability to shield the owners, the equity partners and shareholders of the LLC from liability. What is limited liability? I love this graphic because think of it as this shield, all right? And you have all of these things coming at you in the business world, lawsuits, creditors, taxes. And so by setting up an LLC, you have a limited shield that protects the owners from these hazards that can come up throughout the life of the entity. And I'm going to get into a little more about that shield and what limited means with respect to that. So LLC has a lot of advantages. It's you have limited shield from that liability, flexible management and control. In New Jersey, you can have a LLC managed by the members of the LLC, the owners, or you could have a manager. You could hire someone to do it. It's continuous existence. It's its own separate legal entity, and it's easier to raise capital versus a sole proprietorship or partnership. There are disadvantages. It's more expensive to set up than these other two more simpler entities. More regulations. You have, each state has their own statute and their obligations to comply with those laws when you set up this type of entity. And one of the disadvantages is, or problem, is related to the limited liability part, where you have an LLC that's a single member LLC or have a few members, and that the owners disregard or disrespect the company structure, and they could get into trouble. And I'll get into that in a little more detail. The next type of corporate entity is a C Corp, and that is, also an independent legal entity, and it means that the corporation itself and that the shareholders who own it is held legally liable for the actions and debts of the corporations. There are exceptions where they could pierce that limited liability shield, but typically the larger the corporation that has many shareholders, publicly held companies, usually any of the debts and liabilities of the corporation stand with the corporation and not to the individual shareholders. Lots of advantages for a C Corp. Again, the limited liability aspect, specialty management. Usually managers are hired. They're professional managers of the corporation. Ownership is much more easily transferable when you have a C Corp than other types of legal entities, and much easier to raise capital, and you have the authority and the policy decisions made by a board of directors. Disadvantages is very regulated. Corporations, especially in New Jersey and every other state, they have a separate statute that governs how corporations are formulated and organized. Lack of continuity in the sense that since this entity can survive for decades or even hundreds of years, as some corporations have been around for 300-400 years, that they may change in terms of what they do as a core business. You may have on the other side of that coin are charter restrictions, so that when the corporation is started, there may be some restrictions in there as to what type of business they can engage in, what type of property they can acquire, and the like. Extensive record keeping is necessary when you have a C Corp. And a big drawback is the whole concept of double taxation. And that is when a corporation earns a profit from the income that they bring in, that is taxed. The corporation is taxed on that income, and then when they on that profit, and when they decide to share parts of that profit to the shareholders in the form of dividends, those shareholders will not have to pay a tax on that as income. And the other disadvantage is it's difficult to liquidate. You got these shares, you have, and it's hard to get rid of them if you need to get money that's very liquid. So another type of corporation is an S Corp. It's set up, you have shareholders like a C Corp. You can have a board of directors and the like, but one of the big distinction is that it's taxed like a LLC or partnership. It's passed through to the owners. So there's only a single tax on these entities. Also, they are regulated like S Corps, and it's limited to, I believe, 200 shareholders. So if you plan to have a much larger corporation, or eventually publicly trade that, then C Corp is the way to go. The distinction between an S Corp and LLC is something that you should discuss with your CPA or accountant as to which one of those entities are best for you given your business plan. Let me get back to that shield. Remember that red shield, limited liability? There's a concept called piercing the corporate veil. And that means that there are circumstances where someone can go after the owners of an LLC, the owners of a corporation, under certain circumstances. And that arises when the owners disrespect the integrity of the corporation. And that is that they dominate the corporation to such an extent that the corporation is the alter ego of the shareholders, that the corporation is an instrumentality of the shareholders, and that dominion is used for an improper, illegal, or fraudulent purpose. For example, you have a two-member LLC. You got revenue coming in, and instead of depositing these checks that you're getting from as revenue into the corporate bank account, you deposit it into your personal bank account, or you use corporate employees to work on your bathroom and your house, or you use corporate funds from the checking account to pay your kids' college tuition. Those are some of the examples of disrespecting or the dominion, where there's no difference between the corporation and the shareholders. And the reason that's important is that if you expect to have the shield in place, you need to keep the corporation separate from your own personal affairs. And people say, well, Marco, if I'm an LLC, a single member LLC, how do I get paid? Well, you get paid by either having an employment contract with the business, with the LLC, or taking a draw and then taking that money from there, depositing it in your checking account, and then use your checking account to pay your bills. All right, those are things that you discuss with your CPA and accountant to make sure that you dot your I's and cross your T's. Another factor, another element that courts look to in terms of piercing the veil is if you don't have enough insurance to cover the business operations, if you're undercapitalized. Those are some of the other things. There's a big list of things that courts look to. It's not like a bright line formula. A bunch of different factors, and they basically go on the specific facts of each case. But this is so important for startups to know that, You need to respect the corporate integrity when you set up the business, whether it's LLC, C Corp, S Corp. You need to keep your financing separate. You need to keep everything intact so that, you know, if there's a liability or someone slips and falls in your business and they try to sue the company and you personally, you could defend against these attacks against the veil. So I'm going to jump into contracts and agreement. And I love this slide and this picture here of this tablet that's from 2600 BC. Since the beginning of time, humans have been entering into business transactions and deals. And, you know, some historians say that writing developed because of a need to record these business transactions. And this here is a bill of sale from Samaria that goes back really a bill of sale. And so it's important. It was important back then, thousands of years ago, and it's important now for businesses to understand the concepts of contracts and agreements. They're legally enforceable if done correctly. So what is a contract? Three things make a contract: an offer, an acceptance, and consideration. Think of consideration of the value. You go to a restaurant, you order a pizza, you pay for the pizza. The restaurant owner, their consideration is the value, the money they're getting from offering this pizza to you. And what's your consideration? The value of having a pizza and not having to cook dinner that night. So from that simple transaction to the most complex, you need to have these three to have an enforceable agreement. And so, you know, the next question is, well, can we have oral contracts? Sure, you can. Is it recommended? Not all the time, and mostly not. And you know, I remember growing up in the Bronx, my dad had a butcher shop and he would go to the Bronx Terminal Market and he would work out all these deals with these wholesalers and the shake of a hand. Well, those days are over. And so, you know, it's really not recommended. And there's a thing called Statute of Frauds that goes back to jolly old England, where even contracts that are oral in nature, they're so inherently less reliable that they must be in writing. So that's what the statute of frauds is. You have here a list of different types: extension of credit over 10,000, any transactions regarding real estate, leases over 3 years, and I like the last one here, prenup agreements. Those are inherently unreliable if they're verbal. So the law requires that those are written, which is understandably. What do? I tell my clients when they ask me, typically, general rule of thumb, anything over $500, have some evidence of that transaction in writing. So these are some of the other things that you may see, some of the other agreements that you may see and may be important as part of your business: sales agreements, vendor service contracts, employee agreements, non-disclosure agreements, especially if you have intellectual property. You have employees or other vendors that you work with that are going to have access to CBI, confidential business information, intellectual property, trademarks, patents. You're going to want to have non-compete agreements, severance agreements, confidentiality agreements with these individuals. So you need to contemplate that as part of your business plan and as part of your operations. These are some of the other types of agreements and contracts that you may see as part of your operations. If you have a brick and mortar establishment, you're going to have real estate transactions that you enter into: lease agreements, mortgages, sales agreements, listing agreements. On the IP side, you have several different types of agreements that you may enter into: licensing agreements, assignment, web domain, publishing. If you have an app, you're going to need to have a end user licensing agreement as well as part of the app. Those things that when you download an app, you have to check the box to make sure you read, but nobody does. But look, those are important. Now, I want to finish up the contracts part with some tips, some best practices in dealing with contract negotiation. We could spend a whole day on this subject, but there's a handful of things that you need to know. regardless of how small or large the deal is. Number one, take your time. Okay, I don't care if it's a time is of the essence. You have 48 hours, 72 hours. When you rush things, that's when mistakes happen. So even when you're under the gun, take your time, get professional help. I can't tell you how many times we are approached to represent clients in breach of contract cases when either they downloaded some agreement from the internet or just took somebody else's agreement and signed it without really going over it with legal counsel, and they're involved in litigation and we're there trying to help them out. Please do a thorough background check on your business partners. I know it sounds creepy, but let me tell you, remember that other slide about, get to know who you know, enter into a partnership? Likewise, get to know as much as you can that's reasonable, reasonably obtainable, uh, about your business partners. Have they ever been sued? Are they in debt? Are there any liens or levies against them? You want to know those things before you enter into business with these folks. Um, Always start down. If you're starting from scratch, always write down what the essential terms are. Have a list of essential terms that you agree with the other party to the contract, and then go from there. To the extent your agreement has financing, inventory, anything to do with numbers, do the math yourself. Don't rely on the other side. If you need to get your CPA or accountant involved, do it. If you need to get some other expert involved, to do it. It makes sense to do it upfront. Make sure you know what the numbers say and that you're in agreement with the calculations that you're given. Again, sometimes we may be limited in negotiating the terms of a contract, but go into it understanding and with the attitude that everything is negotiable. Okay, I don't care if it's David or Goliath situation. Go in with the attitude everything is negotiable. Be respectful, courteous, but you could be firm and negotiate. Try to do your best to negotiate, even if it's a type of contract where they tell you up front, we're not going to make a lot of changes to this. Chances are, you it benefits you from trying. Okay. Uh, the other factor is be reasonable and realistic. Okay. Um, Sometimes you may have different expectations than your other potential business partners, but try to be reasonable, realistic, and consult with your attorney. Get another pair of eyes there to see things in case you need a reality check. And finally, and probably most importantly, is please read carefully the final draft of a contract before you sign. I can't tell you how important that is. Okay. If you follow these tips, this will get you going in terms of understanding and negotiating business contracts and agreements as part of your business. So I'm going to turn this next few slides over to my partner, Anthony Davis, who is the head of our IP department. And we do a lot of that type of work, trademark, copyright, uh, theft of trade secrets and the like in the litigation. So Tony, if you're there, go for it.
I'm here. Yeah, great. I'm here and appreciate the opportunity to speak to everyone tonight. I think it's fantastic that in a time of this pandemic and crisis, we have the American spirit and will alive with entrepreneurs, young entrepreneurs who want to sort of sharpen their pencils and their knowledge base to talk about these really critical things for entrepreneurs. And it's really actually a treat to be able to speak to everyone tonight. Sort of, we don't have a ton of time, but I just want to just introduce myself, and then the goal is to go over some of the key topics in intellectual property so that you can identify it and know what we're talking about as it comes up potentially in your business. So I'm a partner in the firm, Santa Massimo Davis. I have been, I went to the University of Michigan undergraduate. I graduated from Syracuse University College of Law in 1992. So I have about 27 years of experience counseling businesses in New York, New Jersey, and throughout the country on intellectual property issues. And my core focus has been trademark, but I've also worked on copyright and patent and trade secret matters also. The big picture of all this is really to say to you, success breeds imitation. Success breeds imitation. So everyone's looking to have the next big hit, the next big company that, you know, is the big success, that has the new app, the new service, the new product that everyone wants. Under those circumstances, you can be sure that anybody else that sees that is going to try and jump in the market. And you can see that from mature markets, right? Just walk down the supermarket aisles, go to the cereal aisle. How many cereals are there? Same box, all different ingredients, all different flavors, different names, and we'll talk about that stuff. But it's a successful product, and those consumer goods is an area that's ripe for things like that. Look at the trends that like a Starbucks started, right? All of a sudden there's a zillion coffee shops, or the the acai bowl phenomenon in the last few years. How many pop-up stores there have been in that space? So with that in mind, the key of this topic that we're going to talk about in the core of the discussion is about how to protect your key assets of your business that you're looking to develop or plan. Just as we go, Marco, I'll ask you to advance slides or not advance slides, so you're good right now. So this is like buying insurance. You know, if you owned a building, you'd buy an insurance policy to cover it from fire risk, no question about it. You'd always do it. The same thing here. When you're investing your time and energy in an idea, an invention, a name, a brand, that you want to protect that, and you want to protect it by taking the basic steps that we're going to talk about tonight to try and protect your intellectual property that you develop. Again, I want you to be able to identify the issues. I'm not going to give you A to Z and what to do or how to do it, but at least you're, as a young entrepreneur, you'll be saying, oh, wait, I have a copyright, I have a trademark, I need to take further action here because I recognize this as intellectual property. So the four main areas that we'll cover are copyright, trademark, patent, and trade secrets. And as you can see on this slide, the reason we talk about these things is because they're assets you should protect. But what we talk about as lawyers is people stealing your copyrights, unauthorized copying, trademark infringement and counterfeiting, people using your trademark or a confusingly similar name to trade off your reputation and your success. Theft of trade secrets. Those are, we're all familiar with the trade secret, right? It's like the Coca-Cola formula. It's a secret. You don't publicly disclose it. You don't tell anyone. But if someone can get their hands on it and make a competing product, you don't have any protection other than the theft of the trade secret. So key to protecting it. Then the final one is patent infringement. Again, we'll talk about that. So next slide, Marco. So let's talk first about trademarks, an area I know well, and you can see here the picture we have of a lot of famous brands and logos. The one top level thing that I'll tell you to help you really understand trademarks is that it is an issue or a concept that's all between your ears. All right, it's a cognitive issue. So it's not looking up a set of rules that, yes, there are a lot of rules, it's helpful to understand, but it really is this connection between a word, name, symbol, sound, color, something that distinguishes your goods and services from others that are being sold by competitors in the marketplace. And it's where our minds go. So you can see here, if you look at any brand logo there, as soon as you see the Adidas logo, your brain takes you somewhere. You see Toyota, you immediately think of cars, excellent cars that have a certain reputation to you based on your own consumer experiences. I always use the example of Champion as a trademark. All right, when I say Champion, a lot of people immediately think of clothing, right? Sweatshirts, sweatpants, shorts, Champion logoed products. I grew up in the Detroit area where cars are, king. Champion makes spark plugs and air filters. That's where my brain goes. They're both registered trademarks. They're both enforceable. They're both, distinctive and distinguished in the marketplace. But I'm just giving you that key concept of if it's up here between the ears, right? And once you register a trademark federally and start using it, and we'll talk about that a little bit, you can keep it forever as long as you maintain it and pay the filing fees and maintain it over time. You can keep it forever. Next slide, Marco. So one of the key things that you probably all know about is, hey, is someone using that name already, right? So clients come to us and say, I've got this great name for a product or service, right? It doesn't matter what the products or services, it's all about the name. And hopefully you've already done your own screening. You've searched Google, other search engines. You've searched every online marketplace, Amazon, Craigslist, you name it, wherever people are buying things, eBay. You've done your own screening. You've done extensive searching. You've looked in the relevant industries. And you can also go on to the trademark electronic search system, which I've got here on the screen. So TESS is publicly available at the USPTO website, easy to find. You can do basic word searches, Boolean searches for combining words with products. But you can basically search and look up in a very simple way if anyone is using the name you've come up with, so that you could start the registration process. There's a little bit more to it than that. The basics are there. The standard is as long as there's no confusingly similar ones. So even in that legal standard, confusingly similar, right? That's in the brain, right? Someone's confused between your product name and another product name or service. So this is where you would start your searching. So you come up with the name, you do a lot of searching online. If the domain name is available and there's no one that's got a similar name to yours that's confusingly similar, you'd come here and search it. And you could actually go through the process and start the registration process yourself. There's nothing stopping you from doing that. Next slide, Marco. So you go through the registration process. We tell people it usually takes 6 to 18 months. There's a lot of information available at the USPTO. There's videos, excellent videos about how to search, how to register, what the process, how it works. And we represent companies and go through that. More mature companies, we actively monitor and maintain portfolios of trademarks because there's ongoing maintenance. We have to do these regular filings. But as an entrepreneur, if you don't want to invest a lot of money in hiring professionals yet, fine. We recommend people do your own searches, do your own filing. If you have a problem with the process, reach out to us. We'll be happy to answer questions and help you get on the right track with it. But it's key to do that because once you put your name in that federal database, just as I'm recommending you search it, everyone else, every lawyer, everyone else looking to see if a name is available is doing those searches. If you've got it filed, everyone is on constructive notice that you're claiming that as a trademark. There's a presumption of ownership once it's registered and you get a certificate of ownership, which is a pretty big deal in a court case where you're trying to sue someone to stop them from using it. So you file it with the Federal Trademark Office, you get exclusive nationwide use of the name, and you can exclude others from using it for confusingly similar goods and services, okay? Next slide. So one of the common questions that comes up is, when can I use the TM symbol or the SM symbol or that little circle R? How do I do it? When do I do it? It's really key to know that if you've got a name for your new product, the new service, your new business that you're going to claim as a trademark, you can start using the TM at any time. Trademark is for goods, SM or service mark is for services. So there's really no critical or no law or critical reason why you would use one or the other. But like a bank provides banking services, they could use the SM. trademark would be, you know, selling sneakers or shoes, a good. But there's really no legal distinction between the two using it. The TM has been widely used for years, and that is something you could easily use, put on your product, your website, your name, your designs, your logos, your brochures, your plans, your business plan. Put your name there and put the TM symbol next to it. You don't have to file anything. You don't have to pay anyone anything. There's no rules about how big it is, where it goes. You can freely use it, and you're letting anyone who sees your business information, you're letting them know you're claiming it as a trademark. Critical distinction here is the little circle with the R in the middle can only be used, only be used, and this is really important, once you've gone through the process of filing and receiving a registration certificate from the USPTO. It's a formal certificate. It's really nice. It's got a gold seal on it, says your trademark on it, who owns it. Once you have that, then you can replace the TM with the circle R. But you can't do that before then, or else the trademark office, if they see you doing that or a competitor sees you doing that, it can be a basis to bar you from ever owning or obtaining the registration. It's a pretty strict rule that's really enforced. All right, so that's a key point, the trademark TM versus the circle R. Next slide, Marco. So let's turn to patents. So patent, as you may all know, is an invention, right? That's the way we think of it. And the critical part about a patent is it gives you an exclusive right. It gives you a monopoly to sell and trade in that invention throughout the United States exclusively for a time period, 20 years. The key to that is it doesn't matter what name is on it. Like trademark, someone could come out with running shoes and call them Nike, and someone else can come out with running shoes and call them Adidas, and the only difference is the name. In patent law, if you succeed in getting a patent, you can exclude all others from selling the product no matter what the name is. You know, one of the easy ones is thinking of like pharmaceutical drugs. If someone comes up with a cure and we see that in New Jersey a lot because of the pharmaceutical industry here. But the patent on a medicine like that, you get it. It doesn't matter what anyone calls it. No one else can sell it. You have the monopoly on it. It's a very specialized area of the law. If you believe you have a patent, it has to be an invention, something that's useful, it's non-obvious, and it has to, you know, sort of take a leap in the current state of the art or the knowledge base that we have. The key thing you have to do is you have to prepare and file a patent application. There's a long, expensive process to do that. And there are a lot of lawyers that specialize in that area, and I highly recommend you consulting with a patent counsel to do that. There are many good patent attorneys in New Jersey that you could call upon to help you evaluate your rights and what it might cost to do a filing and what the value of filing it would be. But just recognize that it's an invention. It could be in the form of software, business practices. There's many types of patents. But just recognizing that you may have an invention, it's more than just a good name, right? It's got to be something new, useful. It really is non-obvious, something not simple, but it's really an invention that you can protect. If you file it, you get the patent rights, then you have to maintain that over the years and take action to exclude others from using it. But the key there is that you do disclose publicly all of the information about your patent. All right, so you've got to be pretty sure that you're going to be successful in getting your patent, because once you put it out there in the public domain, if for some reason you don't get your patent, you've just told the world how to, you know, make your invention, whatever it may be. And a lot of times, you know, we've talked to people about whether the patent is the right path versus maintaining a trade secret, right? So that trade secret would be distinguishable where you don't tell anyone what the secret sauce is in your invention. You keep it to yourself, you keep it under lock and key, you limit the people in your company that know about it, you have, you know, safeguard it in certain ways, And by maintaining that, then you can protect your trade secret, which again is another area. But you may have some invention that you want to just keep secret, and that's totally fine and protectable as long as you take the right legal steps. All right, next slide. So copyrights, another form of protection for intellectual property. I like to always talk about these things in ways that you can sort of put these things in buckets, right? So the trademark is the brand, the name, the reputation, the first thing you know about a company or a product, and it's just the name. The patent is the invention. Doesn't matter what the name is, it's the thing that you've created. A copyright is really the expression of an idea. And when I talk about this with clients, I would usually say, think about like, a love song. How many different love songs have been written, recorded, performed over the generations, right? Even today, every day, everyone's coming up with and every artist has their own spin on it. So you can't own the idea of a love song, but you can own the way it's expressed. So you would copyright, pick your favorite band that writes your favorite song. That band are the authors, and they create and express the idea of whatever they're saying in their song, and that is protectable. Same thing for books, movies, photographs, software. There's a whole list of things that you may be creating for your business that may be copyright protectable. So again, it doesn't matter what you're calling it, but if you're creating movies, you're writing books, you're writing how-to guides, you're creating things, you're expressing ideas, how to solve a problem, how to whatever you're doing. You're creating pictures, you're drawing things, you're writing music. Those are copyrightable. Again, it's a form of intellectual property. The idea is the copyright is created when, under the law, we say when it's some original work is fixed in a tangible medium. Original work fixed in a tangible medium. And I'm saying that so you hear it. That's the key to this. So the day that Picasso made a famous painting, the day he finished it, he just expressed an idea, but he fixed it in a tangible medium. That's the original. And then anyone that wants to make a copy of it, he owns the copyrights. So you need his permission to take a picture of it or make a t-shirt of it or sell a lunchbox with it on the front. All right. That's the key to the copyright. And next slide, Marco. And you don't have to file anything to own a copyright. You can use the Circle C symbol on anything. I recommend all entrepreneurs, you set up a website, in the footer, you see it on every website, copyright Marco Gonzalez Inc. 2020, put it right on every page of your website. Put it on every business plan. Put it on everything you're creating. So you're telling anyone who gets their hands on it, they're on notice that you have a copyright claim to it. You can also register your copyrighted material with the U.S. Copyright Office. Again, they have an online portal, very easy to do. It can get very complicated depending on what you're doing, but there's a lot of online guidance about how to do it, and the reason to do it is because it gives you additional rights. So if someone, you have a great picture or a great photograph that everyone starts, using, if you have the filed registered copyright, then you have additional statutory and legal rights when you go to court to sue them and recover damages. Very helpful. And in these, social media times and where we are with all the apps and the generation of sharing, it can happen quickly and exponentially. So if you're a professional photographer, or you may want to be copywriting your key pictures. It's hard to pick and choose, but that's something that you can do. Same thing with books, with things you're writing. You can easily register them now with the Copyright Office. And again, you don't need to have it filed and registered in order to use the Circle C, unlike trademark. Next slide, Marco. So here we just captured some of the key things about copyright, and infringement is the area that we're typically talking about. Once you've protected your rights, then someone may come to us and say, hey, someone's misusing our copyrighted materials. You know, what do we do? Well, if it's a valid copyright, and someone had access to that copyrighted work and they're duplicating it without your authorization or permission, then you can bring a legal action. Typically, we put them on written notice first, hopefully to have some dialogue with them about what they're doing, why they're doing it, and best thing is to reach a business resolution of that dispute. And then the next resort would be going to court to sue them to stop their misuse of your copyrighted materials. On the right, we show that there are some exceptions, right? Fair use, some have heard of that, but that would be a defense to someone using your copyrighted materials, like for educational, instructional activities like tonight, something we're presenting. You know, Adidas isn't going to bring in action against us for using their trademark name and its copyrighted logo in one of our slides. So, but that's sort of the big picture of copyright. Next slide, Marco. So in this slide, what we've captured is the just absolute ton of information that's publicly available for inventors, entrepreneurs, and in particular, like here at the U.S. Patent and Trademark Office. So you can go right to the source rather than reading what someone else is telling you how to do it. They have videos, they have guidance. There's about trademarks and patents. The Copyright Office has the same thing on their website. But I encourage you, to look at these things. If you think, oh, well, we do have a good trademark, we do have a good name, I might have a copyright, maybe it's a patent, spend some time here. The thing that you all know from being students at a great university is knowledge is power, right? So if you can learn it yourself, like taking the time to listen in tonight, learn the basics yourself, educate yourself about some of these things, and then be educated about how to protect your assets and your time and investment in your business that you're starting. That is time well spent and will pay dividends, whether you're hiring attorneys or professionals to help you. You will know what's going on, and if you're going to own and operate your business as the leader of the business, you really have to know these things, so you're not just relying completely on outside advisors all the time to give you all of your advice. You need to be guiding, and steering the ship about where you're going, what you're protecting, how you're spending your money, how you're spending your time and your intellectual capital of your business. So again, these were just some of the main topics I wanted to share with you after doing this for years and helping entrepreneurs and small businesses and large businesses with these issues. It's not always easy to do, but if you take time, look into it, I'm sure you'll find the answers. And we're here to help. If anybody has any questions, our names are on the slides. You can find us on our website, and then get to us by email, and we're happy to help. So I think that was my last slide, and I'm going to turn it over now to one of my colleagues, Marco, switching gears, right?
Yes, thanks, Tony. What we're going to do is we did have some other slides, but we're running out of time. We're going to give the PowerPoint to you guys, and certainly if you have any questions on the compliance or litigation front, you could talk to us about it, but we're going to go and finish the presentation right now and go into the Q&A mode.
Yeah, and Marco, we do have till 8:30, so
Okay.
pace it as you will.
Okay, Chris, I'll
Yeah.
take it over. You can take it over for now.
Great. Why don't we let's answer some questions, and if there's time toward the end, we can certainly go back and have a conversation about what's on the remaining slides. So So it looks like we have a bunch of questions in the chat here. So the first question is, what are the requirements for a foreign citizen to set up a business in the U.S.?
Well, that one, I've dealt with that before. There's really no restrictions, or you can set up a business and own it. The question is, how are you going to benefit from it if you don't have the proper visa and social security number? But there is no prohibition on a foreign person owning and starting a business. It's just whether or not your immigration status allows you to remain here to operate that business would be your challenge. But you could also own it and operate it from a foreign country. No problem with that, as long as you're compliant with you file your business just like anyone here would file and register an LLC or a corporation, whatever business you choose. Comply with other things, and if you have employees, you pay them properly, and you collect money, pay taxes, follow all the requirements and the annual filings and registrations. No problems.
Great. So some of the questions that we might run across, including the one I'm going to get to in a second, might be a little bit too complex to answer in this forum, or they might be a little bit outside what we typically do, and you'll get an example of that now. One of the folks has an LLC from which he does some public speaking and consulting, and a 501c3 tax-exempt company. He wants to know whether he should be an employee of one, or maybe merge the two and create a parent company to house both of those entities. That's a little bit too difficult for us to answer given the tax implications there. So I think that's something that you're going to want to speak with an accountant about to make that determination. So next question we have is, if a business decides to file as to become an LLC, does that affect its ability to receive venture capital?
You mean receive venture capital, like someone to invest in the company?
Yeah, I think the answer there is that the LLC is really the business entity, and there are some limitations about who can own an LLC and how many owners there can be, but in general, it should not hurt your ability to seek venture capital. There was always the ability, once your business takes off and becomes the next IBM, you can always change the form later on and convert it to an S or a C corporation if you need to. So, and another related question, whether the COVID-19 crisis is causing a lag in forming LLCs and C corporations. I haven't heard that, but I would tell you that the state website where you would go to form an LLC or establish a corporation, they are really taxed at the moment. So if you're experiencing some lag, or you're experiencing a lag in response time, it could be either that the systems are really taxed, or the people are physically not in the office and able to process things. I think in general that the New Jersey website where you can form these entities is pretty self-sufficient without too much intervention. So hopefully the crisis won't cause you too much of a delay. So here's a question maybe for Tony. How can you do market research while protecting an idea for an invention?
Yeah, that's a good one. Yeah, everyone has, you've got your idea, your plan, your product, whatever it is, and you start researching it. You just have to keep it to yourself. And that's the thing, is not to share it and disclose it to others, unless you have like a non-disclosure agreement with someone, a contractual agreement where they agree to not disclose or use your idea or your information. But that can be tricky in the beginning. And that's why you want to do your own research, like reserving website domain names if they're available, doing your own trademark filing. But we do routinely do that. We watch what competitors are doing, looking up what trademarks they're filing, because they may be venturing into new markets and our clients want to keep up with what they're doing. So we do watch those filings. It can be hard. You really want to do a lot of planning, a lot of prep work. And then when you're ready, you really want to launch it and do the proper filings and reserving web domains, and then really move forward with your idea and your new business.
Great. So there's a couple of other folks from our firm, from our team that are on the line and here to answer some questions, including Alicia Chan and Alex Anglin. Alex, here's a question for you. If you run an LLC that deals with mentoring students on school grounds, including the New York City Department of Education, is there a legal need to secure insurance to work with students?
Yeah, there almost certainly is. Some of that's going to be driven by the organization you're dealing with. So NYC DOE probably has insurance requirements for anybody who's coming to their premises and providing services. They're probably going to hand that to you in the form of a written document and say that you need to show that you've got the following types of insurance in order to come to their location and provide services. Just like we recommend with our private clients that they insist that vendors that come to their locations have appropriate insurance. So if you're doing that, you're going to want to make sure you have an insurance broker who can take a look at the insurance requirements and either verify that you've got it or go into the marketplace and get you what you need. And for entrepreneurs particularly, I would just encourage them to keep in mind that insurance brokers make money on premiums. They get a percentage of the premiums, usually about 15%. So if you're spending very little money on insurance, you're likely to get very little service from your broker. You want to find a broker who's investing in you, understands that you're likely to become a much larger entity, and for that reason, they'll bet on you and give you a little bit better, higher level of service than might be warranted based on the very small fee they're likely to make.
Alex, in terms of, you just mentioned the broker in the process of buying insurance. Any thoughts about, what an entrepreneur should be doing in terms of, securing a broker and the type of conversation you ought to have with the broker when you start out and you're buying your first package of insurance?
Yeah, I do. I think you want to find someone, if you can, who has some experience with the industry that you're in. Brokers do acquire some knowledge and specialization based on the industries that they serve. So certain brokers may be more knowledgeable regarding transportation, trucking, warehousing. Other brokers might be more knowledgeable regarding the needs of technology companies, things like that. If you can find brokers, an insurance broker who has a book of business where a substantial amount of it is in your industry, that's going to be an advantage. If you can find one who's serviced entrepreneurs from startup as they grow and got larger and acquired new risks and they're acquainted with that process, again, that's going to be an advantage for you as an entrepreneur.
Great. Here's another, this is an interesting copyright question from Faith. Is it possible to protect a written idea for a business through a copyright? Let's say you write down the idea somewhere and you sort of want to protect it from others taking the idea, I assume, Faith, is what you're asking?
Yeah, this is Faith there?
Yes, I'm here. That's what I was asking.
Yeah, and I think one of the other participants who's a law student answered it properly right after it. It's the copyright's created at the time of creation, and it is the author that owns the copyrights. Typically the copyright application says, yeah, those rights, have been assigned to a company, but it doesn't have to be. So the author, the creator, is the one who has the right to file and own the copyright. You don't have to have a business form to do that for it to be valid or to own it. A person can own a copyright, no problem.
Okay, thank you.
You got it. Thanks, Brian.
I want to look at it from a little bit of a different angle for a second. So you write down the idea on a piece of paper in your notebook, an idea about a new business that you want to form, maybe to build a certain type of product. The idea itself, is it protectable at that point? It's the piece of paper can't be copied if it has a copyright, but can the idea itself be protected, by writing it down and getting a copyright on the written work?
You would have to express that idea in some tangible medium. I guess you could write it on a piece of paper, take that image and copyright it. But I mean, I think you'd need a full-blown business proposal and outline, but I don't think that would be making that public wouldn't be helpful to try and copyright the idea itself. You really, the better place would be if it's a really good idea, an invention, evaluate it for patent rights, and then also come up with a really distinctive, unique name that's a strong trademark to protect you from competitors, especially if it's something that's not patentable and that's going to be copied by other people in the marketplace. And that's what's hard. If you're joining a mature market where you've got competitors that are in the industry, have lots of resources, have money, manufacturing, salespeople, national marketing and distribution, it's really hard to go up against those, even if you have a great idea, because they're going to see your idea, your product, put a different name on it. If it's not patentable, start making it and competing with you. And the copyright isn't going to really give you the best protection to stop them, because they'll make it distinct, they'll make it different enough to avoid your copyright claim, put their own name on it so there's no trademark issue, and then you're competing. So that's really the challenge with a startup business. You've got to really be unique, distinctive, and you can't just necessarily file a piece of paper with the Copyright Office that then gives you some monopoly on that idea. Very difficult to do that.
Okay. Yeah, the idea itself is more for it's a software, but we needed like more time to actually develop it, and it's something that could easily be incorporated into like the IP of competitors are already in the market and the major players there. So we were looking for ways to possibly protect it while we worked on it and brought it out.
While you're working on it, who would have access to it? Who would be able to see it or use it?
Well, right now we've entered a couple of startup competitions. So like a couple of people have heard what it is, even though they don't know exactly how like the innards work, like how the code is, but they know the idea itself.
Got it. I think if I think one of the ways to protect yourself would to be really to have some non-disclosure agreements. And then that is one of the challenges of keeping, sort of this information protectable, even when you're entering these contests, even, something like that Seton Hall puts on. It's a great way to get exposure, but if you're not really mature enough, or your business isn't matured enough, or it hasn't got to a stage where you feel like you can protect it or is protected, you may want to not, offer that information into different contests. Just my humble opinion. Not that the contests aren't great, but maybe you're just a little bit too early to do that. What do you guys think?
Yeah, I mean, once you make it public, it's a little bit difficult to put it back in a box and prevent other people from either seeing it or maybe try to, take it away from you. So it's tough. It's tough to balance that desire to get it out in the public and look for financing and look for support for it with the desire to keep it private.
This reminds me of years ago. This isn't my area; it's more Tony's area. But years ago, there was a lot of effort to patent business methods, right? And ultimately, I think that ended up being that there was not much of an ability to provide patent protection for what were basically business ideas, because there was this desire to use the patent law to do that. But it's kind of square peg in a round hole.
Yeah. Well, this discussion kind of dovetails nicely into another question, which is, what's a confidentiality agreement and how do you use it, and is it effective? I'll just talk about a little experience around it. So a confidentiality agreement is really a contract that people use in order to protect information from being disclosed to third parties. As an entrepreneur, you might think about using a confidentiality agreement with your potential partners or people that you're discussing an idea with for financing purposes. And the document is going to basically say that typically to be a mutual agreement, and either side might contribute some information about an idea or about a potential business relationship to each other. It's private, it's got value, and it needs to be kept confidential and not shared with anybody who's not a signer of the agreement. And there's ways, there was things you would specify in the agreement about how to enforce it and such, but it's basically going to say that if it's not information in the public domain, that you shouldn't share it, and you shouldn't you shouldn't release it to anybody who's not signing on to the agreement. I think it's a great thing to do, and it's something that you ought to think about every time you get into a new business relationship, because it's going to set the stage for people to freely share information. And hopefully you don't have to worry about enforcement, but if one side breaches, typically you would be looking for an injunction. That is a court order that puts the information back in the box of confidentiality, and maybe there's money damages as well. But again, hopefully the parties that sign on to it are going to observe it and behave themselves. And especially when you talk about information that's on a computer or on a computer network, the agreement might say something about the standard of protection that you have to use to make sure that people don't hack your system and get into it and steal the idea. Anything you guys want to add to that? Okay. And let's see. When, Tony, this is for you. When do you recommend getting legal advice about filing the trademark or filing a trademark? Are there any specific cases when it might be necessary, and does it depend on the category that you select?
Yeah, so let me take that backwards. It doesn't really depend on the category of goods or services. It just depends on what level of protection you want to give the company, right, or your new business. So you can, like I said, I tried to give some beginning steps so that you could do your own homework, research it, potentially even do your own filing if you did your own homework. When you would want to get legal advice is if you don't have the time or the inclination to do some of the homework yourself, and you think you're going to have a big investment in this company where you say, you know what, we're going to put a lot of money into the product. And I always think about packaging if it's goods, right? If you're going to print thousands of labels and boxes and make up all kinds of marketing materials and point of purchase things where changing that name is going to be a problem, then you really want to invest some time and money in getting good legal counsel to help screen that name and make sure that when you start using it, you don't immediately draw a notice from a competitor that says, don't use that name in connection with those goods. It's too close to ours, and and then you've started off your business with a problem, and then you might have to change your name. So that's where I would really, those are the cases where it doesn't matter the category, but it's more about sort of what you're doing and the investment you're making in the business and the direction you're taking it. So that's my experience with it.
Great. Next question, I think it might be a little outside our area, but I'll throw it out there. It's about a provisional patent. Whether we have any thoughts about filing a provisional patent to protect an invention or software as you gather market research through product sampling and approach potential investors.
I've had, again, as I said in the beginning, I'm not a patent attorney. I've counseled clients with patents. We've always referred to specialists. I would have to defer to that, but I know there's some value in provisional patents, but I, again, would be very careful about what you're publicly disclosing about an invention before you have a really clear understanding of your ability to obtain patent protection through the filing of the patent, because even the provisional filing, you're disclosing information about your invention. And once you do that, if you don't obtain, the patent protection, it's just out there in the public domain for anybody to take and use. And then your only protection is you're fighting over maybe the brand name or a trademark name, but a bigger competitor with bigger resources could beat you to market, and then, you don't have anything. So that's a tough choice for sure.
Next question, real good one. What's the biggest legal mistake that new entrepreneurs make? Maybe we can go around and do a round robin on this one, but I'll start real quick. I think Marco actually spent a little bit of time talking about picking your partners. I think the biggest mistake that I've found is that people get together and maybe they're friends or maybe they're just acquaintances that they met on campus, and they've got these great ideas. And they start brainstorming ideas, and they kind of get ahead of themselves, and they don't, do some of the homework that we talked about today, but in particular, having an agreement among themselves about who owns what and who's responsible for what and what is everybody contributing. Because if you do that homework first, it's really going to set the stage for a lot of the other stuff that entrepreneurs ought to be thinking about. And then that's also going to help you determine whether the people you're talking to should be your partners or not. So, Alex?
Yeah,
I'm sorry, Mark.
sorry.
Go
No,
ahead,
one
Mark.
of the things I've seen in representing small businesses as general counsel of the statewide Hispanic Chamber is you have a lot of startups. They have a business plan, but they don't have a section on the law. What are the things basically what's we discussed? You should have in your business plan a law section that goes over, the things you need in terms of business formation, the things that we talked about, intellectual property. You need to have that as part of your business plan, and that's something that I see a lot as a problem, because then they have this nice business plan, they're trying to get funding, and there's issues. They didn't comply with certain statutes or regulations, or they didn't brand, or they didn't register the trademark, and those are things that they have to fix on the fly.
I was going to say the same thing you said, Chris, which has got to be skimping on those initial agreements among the members of the business, the participants of the business. If it's an LLC, an operating agreement, a partnership agreement, shareholders agreement, whatever form there is, there's an appropriate agreement that says what the promises are, what the rights are of the respective parties, and very importantly, with a little bit of imagination, sets out a means for resolving problems that might occur. Problems like we no longer agree with one another, we disagree on the direction of the business, one of the partners no longer has enough money to contribute in the case the partnership or the company needs more money, like a capital call. All those things could be set out in writing in advance, could avoid a lot of pain later. Also, and equally, younger entrepreneurs might not be thinking about it, but the death or incapacity of one of the members of the business could be a big issue if it's not spelled out in writing. So all of those things, probably the biggest mistake, and nobody thinks about it early on. And then if the business starts to go good, they forget about it. It goes further in the rearview mirror, and then you're 5-10 years down the road and you got a disaster.
Yeah, and I couldn't agree more that having the lack of clear understanding between the people that start the business, whether they take some time to sit down and define it, even if you write it out, your own bullet points, doesn't have to be a final formal contract, but at least you're talking about who's responsible for what, who owns what, who's going to share in the liabilities and the successes of the company. And I always think of that the Facebook company, right? The movie is what I think of, right? Think about that whole movie is just about the absolute mess that they were in, from starting up in college, this great business idea that took off, who owned it, who was involved in it, who founded it. The whole movie is about the litigation and lawsuits, and these are all young entrepreneurs who are involved in really high stakes litigation and big payments, and look where the company is now. I mean, that's the rare example, but that all was because they just sort of ran with it and never sat down and spelled out who owned what, and then started, everyone again was, claiming they did something, and big disagreements. So couldn't agree with you guys more on that one.
You know what the obvious difference though in that situation, the real problem those folks had, they went to Harvard. If they'd gone to Seton Hall, had a seminar like this, they probably would have been in much better shape.
Sure. Good point. That's the best point you made all day. Good job.
I can call it quits now.
Yeah, you can take the rest of the night off. Next question. If you make a film for a class, would the copyright belong to you or the college?
It depends what your agreement with the college says, right? So you probably signed up somewhere, there's an agreement regarding that class, some release form that you signed or filled out when you signed up for the class. I would take a few minutes to try and figure out what you've agreed to. If there's no agreement, then you're the author of that film and you would own the copyright to it. You would be the author of the original film and you would own the copyrights to it as long as you're the sole author of it. If you have other people assisting you, they may have co-authorship rights, and then you'd need agreements with them to ensure that you have all of the rights to the film. But likely you signed something that may have addressed that with the university. It would be somewhat standard practice for a class like that.
Great. Next question came from Brian, whether we'd recommend working with the SCORE organization. Brian, I think that you're referring to that network of volunteer mentors. If I'm right about that, I'm not really familiar with the details of it.
If I can jump in, it's Susan Sherrick, who runs the entrepreneurship program, Brian. We have worked with SCORE volunteers for years. They're fantastic. It's a national network with offices in New Jersey of retired executives. And basically anybody can walk into their offices off the street and they'll help you write a business plan. They hold no cost or low cost workshops. They work as mentors to our students. And if you're at the Seton Hall Law School, there's actually a SCORE office in the Gateway building, and I would highly recommend it. They're a wonderful resource, and they've been around for decades.
Great. Next question might actually need a team effort for an answer. It's a really interesting question. So do you as the entrepreneur have to know all the mathematics and exactly how your invention works, or can you have someone do it for you in order to produce a product? And that came from Brendan. Brendan, that brings together a bunch of different concepts that we talked about today. I'll start a little bit on the employment and contract side for a second. So let's say that you're an entrepreneur and you followed Marco's advice and you formed an LLC and you're going to do business. And maybe the business is going to begin as, the R&D effort to create a product. You can certainly hire employees, or you can hire independent contractors in some fashion to do that for you. But when, we talked about this planning that you need to do. This is the perfect place to start, is making sure that the people working for you understand what their role is going to be and what they own and what they don't own. If you were to hire somebody as an employee for your LLC to do some of this work for you, or whether they're an independent contractor, maybe they've got their own business or they work for other people and they work for you part-time, whichever it is, you're going to have to make sure that you have them sign an agreement to say that anything they invent that you're paying them for is going to belong to the LLC. It's called an assignment of intellectual property rights, an assignment of patent rights, or an assignment of anything else they create. So you just need to know that they're being paid a salary, or maybe they're paid an hourly wage, or in the case of a contractor, they're paid some other sort of fee. But anything they create belongs to the LLC. So you can delegate it if you want to other people. You just have to set it up the right way. Anything you guys want to add to that?
No, I think that's exactly right. The critical part of that is that you may have the idea, if you hire a bunch of people to help you, you better have solid contracts to ensure that you own all the rights to all the ideas that they develop, the work made for hire, language, to make sure you own the fruits of their labor are owned by you and not by them individually.
Yeah, in fact, if you were to go to the Patent and Trademark Office and look up a patent or two, you might find that it's in the name of the individual inventor, and that person could work for some company that financed the creation of the patent. So they're the patent, they're the person that signed the patent and filed it, but in reality, it probably belongs to their employer in most cases, and that's the result of the kind of contract we're talking about today. Looks like that's the end of the questions so far.
Yeah. Any more questions, anyone?
How much does it cost to form an LLC? I think the filing fees are under $100, right, for that?
I think it's 125, 127 in New Jersey, and it can be done all online.
Yep.
Great. Well, if our attorneys are finished, our attorneys, do you have any? Oh, we have one more question, and then maybe I will ask each of you to make a concluding remark.
The last question here is, I think this goes back to the question about whether a student or the university owns the film. It's can a faculty developing a product as part of, let's see, basically does a faculty member have ownership in the product that they're creating as part of a scholarship or under a scholarship? As Tony said, I think that's going to be found in an agreement that you might have related to the scholarship. So I would advise you to check the agreements and the releases that you signed as part of the scholarship program. Okay. Looks like that's the last question, Susan.
Right. So you've all been absolutely terrific, but perhaps before we close, you could all make a closing remark, one piece of advice that you would give a student entrepreneur starting out with their startup, developing their business model, or maybe they've launched and.
Go ahead, Marco, why don't you start?
Yeah, look, don't be afraid to ask for professional help. And what's that saying? Penny wise, pound foolish. I can't tell you how many times I've seen that people trying to save money up front and either doing a contract or setting something up. They don't want to pay the legal fees up front, and then they get into trouble later and they wind up getting a litigation that costs tens to hundreds of thousands of dollars. So, be prepared, always be prepared, ask for help, and be wise and spend the money up front, and you'll thank yourself later on. Trust me.
Great. Good, Tony.
I would say, listen to advice of successful people. Take a lot of things away from what we're saying. But one of the things I've seen with great entrepreneurs is that they're ready to pivot, right? So you got a great idea. Don't get too chained down to that one idea, right? Like be open to modifying it, changing it. Netflix, if you don't know that story, read the history of that company, and you'll see how companies can pivot. But keep that in mind. That's something you should really keep your eyes open and be ready to move and change with whatever is happening.
Yeah, I would say, just in closing, entrepreneurs are focused on new ideas, new things, original thoughts, original ideas. That all is great, but you have to remember that you're a business person. And if you really look around, the vast majority of business success is based on excellent execution. I just think of two of the most valuable businesses in the entire world are Walmart and Amazon, and the things that have made them better are just that they took the execution to a higher level, right? Whether it was inventory control, using technology, just squeezing all of the slack out of everything that they did. So even an entrepreneur with a great new idea, building a better mousetrap, that's great, but you have to be a business person, be really smart about your execution, conserve your resources, spend on what matters, and work with really good people, because everything that you do has to be done really, really well. And if you're not working with good people, that's not going to happen, and your idea is not going to get to be built into the thing that you really want to build it into, that vision that you have.
Yep. I guess the last thing I would say is that we're so lucky to be connected in a little way to Seton Hall, and in particular we're lucky because you guys have such great energy and great ideas and a lot of excitement, and you move really fast, and that's wonderful, and that's part of the creative process, and that's what makes you guys so successful. And you should continue to do that and continue to develop those ideas and have that energy. But the one piece of advice I would give you is don't be afraid to slow down and plan. It's great to brainstorm at light speed, but when it comes to the details and about the things we're talking about today, spend the time to sit down and plan. Put it down on paper, write down what you need to do and how, in what order you need to do it, and then take care of these little details. They're little details in the beginning, but they become details that are really big at the end if you don't deal with them. Like Marco said, they tend to balloon and snowball quite a bit. So keep rocking and rolling really quick on the brainstorming and the entrepreneurial spirit, but slow down and take a breath and focus on this important stuff before it's too late. As Marco said, you'll thank yourself later for sure.
I'd like to very much thank the law firm of Santomassino and Davis for coming here tonight for our Ask a Lawyer workshop. And a lot of questions were asked of our lawyers. And I'd also like to point out that this fantastic law firm is the legal sponsor of our Pirates Pitch startup contest. So thank you so much for coming here tonight to Seton Hall to our absolutely terrific legal workshop. We had a lot of questions. We had lots of great participation, and we look forward to working with you in the future. And I'd like to thank all the students and faculty who also participated in absolutely intriguing, interesting, and very absorbing workshop, which shows that entrepreneurship really lends itself to the virtual format. And thank you so much for your time and all your wisdom. Okay, and good night, everyone. Thank you very much.
Thank you.
Thank you.
Thank you.
Thanks for having us.
Okay, thank you.